Item 1.
It online is no, one, no.
Not one.
Not one. Item number
42.
42, 43.
May I please?
Item number 42 and 43.
Yes.
This is a challenge to the advertisement of the Department of Elementary Education, which is inviting applications to teachers' vacancies. And they have non-suited those who have an 18-month diploma from the NIOS under the MHRD direction. The Lordship is probably aware of all of that. Now, Milad, the reliance is on a Supreme Court. Can your Lordships hear me, Milad?
Yeah. Loud and
Yeah. The reliance is on a Supreme Court judgment, and on the basis of which this non-suiting has happened. Now, Milad, my submissions are, I have 3 submissions which are independent and alternate. The first is that it's a complete misreading of the Supreme Court judgment to say that the 18 months course has been de-recognized, because the Supreme Court judgment, and I will take a Lordship's way, very clearly says that this is a one-time window of opportunity for in-service teachers, for which the second proviso to Section 23, subsection 2 was brought about, and to give them the minimum qualification in terms of Section 23. So once, Milad, I am qualified, the question, therefore, of my being non-suited is does not arise. And the court also, Supreme Court also said that these will not apply to fresh applications. So basically, all those who were in service in 2015-17, whenever the amendment came into force, and if they had acquired that 18-month diploma, would be at par with the rest, and therefore acquires qualification under Section 23. But that's one. 2, Milad, the judgment also in terms of equivalence. Now, because the second submission, it says that there's a finding of the court, and correctly so in the case of, because in the case of Uttarakhand, they have the court was considering the matter, there was a 2-year stipulation. The court said that there can be no equivalence when the rule says 2 years, and you cannot therefore have an equivalence in 18 months. But it also showed the way when in paragraph 51, the court says that all that it is required is for the NCT, who respondent number 4 before your Lordship, is to issue a circular under Section 23(1) saying that 18-month course is also applicable. And I would submit, Milad, that NCT already having issued a regulation under the NCT Act saying that the 18-month course is a valid one. All that it is required, Milad, that a mandamus can be issued to them, because it is already their stated stand that they can issue, if the need arises, to issue a circular superseding that 2 years and saying that 18 months is also applicable. And
that's
thirdly, Milad,
your projected case.
Yes.
That's
and third, projected in the pleading, but Milad, on a careful reading of the judgment.
Mr. Hazarika, can I just some queries, if I can just ask. The scheme of things that was there in that 18 months course was limited to the in-service teachers.
Absolutely.
To make them at par with the qualifications under the RTE Act.
Absolutely.
Then the regulations of NCT, which was holding the field 10, 12, 14, were never corrected or were never amended. It continued to have that 2-year prescription. I have failed to find out, that's what I want from you. I failed to find out a notification from or a decision of the NCT saying that these 2 qualifications are the same. Now, this equivalence came to be declared by the Patna High Court, right? Followed by the Tripura High Court. So, beyond these 2 judgments, is there an independent decision of the NCT that these 2 qualifications are the same, equivalent? One.
I would put it.
Second query. The rules that we have here in the state says no qualification is prescribed. It says it will be in tune with the qualifications that would be prescribed by NCT from time to time. That you will get it in page 293 of that manual.
Yes.
Now, NCT having not amended it, and the Supreme Court having said that the law laid down by Patna High Court is a bad law, where do we stand today?
No, Milad, that is why, Milad, the first submission was important. Because the Supreme Court made a let me first address your first 2 queries, Milad. Milad, there are the NCT regulations at page 129 here of 22nd of September 2017. which my lords are issued because in terms of a section 57 direction. Your lordships have page 129, my lords.
I got it.
Yeah. So this is of 22nd of September or 2017. What does it say, my lords? If your lordships will come to page 131, I will, my lords, and no, my lords, I will read from the beginning because this is important. I will read, my lords, 2, 3. The first recital, whereas the matter of recognition, my lords, I'm reading from page 129, your lordship. I'll read it carefully.
Okay.
The 129, whereas the matter of recognition of the project proposal of NIOS program through Swayam portal for training of in-service untrained teachers are considered by NRC, and NRC overserved as follows. Whereas NCT has received directions under section 29 of the NCT Act from the Ministry of Human Resource Development. We did a letters number so-and-so. The project proposal for recognition of diploma in elementary education program through ODL mode has been submitted by National Institute of Open Schooling to NCT headquarters. The proposal is for conducting online DEID program through the Swayam portal of the Ministry of HRD for the in-service untrained teachers at elementary level working in government and government-aided private schools. So therefore, it is for in-service teachers and it is pursuant to the direction of the MHRD. Then I'll come to the last recital. And whereas in view of the above mentioned directions, of human resource development under section 29 of the NCT, because under the NCT Act the issue, in exercise of the powers under clause 12 of so-and-so regulation, granted relaxation with a NCT headquarters letter number so-and-so dated 21st of September, letter dated 22nd to the following, 22nd of September to the following provisions in the NCT regulations for ensuring that the directives of the MHRD for implementing the amendment to the RTA Act. What is the amendment to the RTA Act? That they have to be eligible in terms of section 23. So therefore, it therefore, though it is not stated, but that it is not a question of an equivalence. It is a question of a qualification being acquired under section 20. Now, my lords, therefore, now, if you big to come big Roman 2, any provision relating to the duration of the program so as to reduce it to 18 months instead of 2 years and the requirement of 6 months internship to be subsumed within the duration of 18 months. Now, Roman 3. Any requirement of minimum eligibility for admission to DED program, that is 50% marks in class 12 to the extent that those who do not fulfill this requirement should be allowed to take provisional admission to a program subject to their acquiring 50% marks for completion of the DED program. Now, Roman 5. Any provision of the number of people who are affected. Any provision prescribing the number and nature of study centers to enable NIOS to cater to around 10 and 11 lakh untrained teachers. So in Assam alone, 11 lakh applied. And there are at least 165 before your lordship. Now your lordship will turn over the page to 131. So now these are the directions. Recognitions. After having considered, whereas was the first recital on this page. And after having considered all the above facts and figures, the NRC considered the case in its 27.5, so decided that recognition to be granted to the National Institute of Open Schooling, Noida, for DEID program to Swayam portal of MHRD for training of in-service untrained teachers. This is a separate category under section 14 of the NCT Act.
I got it. Any direction you want to highlight here in page 131?
It is a recognition. It is not a direction. It is recognition. Once it is recognized, then it comes within the ambit of section 23(1). Now, may I take your lordship to the judgment? Because the judgment makes a distinction between fresh recruitment. That is why they said this is only a one-time window of opportunity. It's a 249.
I think there is a further rider by the Supreme Court that this was only for the in-service category.
Yes, but there are no. So today, my lord, the petitioners before your lordships are all in service.
If this program 18 months was open to all,
yes,
then it would have been a different ballgame altogether. But it was only limited to the in-service teachers and for the purpose to have them qualified in terms of the RTA Act.
Exactly.
Now, it has also come on note that is 18 months was required because that was the only time left for the last day for compliance of the RTA Act. And these things have been gone into by the Supreme Court.
Please. And the court says, makes the distinction. So therefore, it says it cannot apply to a fresh recruitment, not to untrained teachers. In fact, I will take a lordship to the penultimate paragraphs, but I can also...
Mr. Hazarika, while we are considering the Supreme Court judgment or understanding the Supreme Court judgment, we'll also have to take note of the fact that that case was filed by persons aggrieved by the Uttarakhand High Court following Patna bench.
Please, Manoj.
That has to be always behind us, in our mind.
True.
It was by the persons who were having that 2-year degree who has
Please,
come
Manoj.
up.
Please, Manoj.
Please proceed.
So, Manoj, at page 257 is where the discussion starts, and where at paragraph 31 is where, Manoj, they extract the section 23. Since your lordship has read it, I will not trouble your lordships with that.
We can come to page 35.
Paragraph 35?
Yes.
Yes, Manoj. The government of, Manoj, if your lordships don't mind, I wanted to first show you to your lordship, because I will come to Uttarakhand
Okay,
separately.
fine. Be comfortable wherever you want.
Because, Manoj, if I may say so, I want to show, Manoj, how the Supreme Court has very clearly said for in-training teachers and makes a distinction as a class, as a separate class. So, Uttarakhand is a separate stand of my submission. If your lordship don't mind, I'll come to that a little later. So, basically, paragraph 33, because these are the what your lordship has followed from my lordship, what precisely the Supreme Court has said, paragraph 33. Through the 2017 Act, Amendment Act, a second proviso was added to subsection 2 of section 23 of the RTE Act with retrospective effect from 1st of April 2018. It provides that every teacher appointed or in position as on 31st of March who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the 2017 Act. So this is 34. It can be further seen that in exercise of powers conferred under section 1 of 23 of the RTE Act, central government authorized NCT as an authority, academic authority, to lay down the minimum qualification for a person to be eligible for appointment as teacher. Accordingly, NCT issued notification on 23rd of August 2020 prescribing the minimum qualification. The said notification came to be amended by dated 29th of July. Was an exercise of powers. This is not so relevant. Then I'll take your lordships with us next to page 30, paragraph 38. Paragraph 38, your lordship has?
You can have just 36 words.
Please. NCT in exercise of powers conferred under section BD, clause DD of 32 of 32, read with section 12 capital A of NCT Act, notified 2014 regulation, providing for minimum qualification. Insofar as classes 1 to 8 are concerned, the minimum qualification as recognized in the earlier notification remains the same. And which is the 2 years, because they added that 23rd of August notification. Now, there is no dispute on that score. Because what I'm trying to say, that this relates to the general norm, to the statutory general norm. This is today what we have before your lordship is an exception. So that exception
41 and 42 is pertaining to that course, the observations of the dealing with that scheme. 41 and 40.
Please. 41 and 40. Your lordships, since your lordships have gone ahead, because in fact, at paragraph 38 and 39, it takes note of those regulations that I pointed out to your lordship.
Right. 43.
43, my lords, if I may come back. All right. In fact, 40. Okay,
you can take me through 42. That will be relevant here.
Yes, my lord, that's what I want to do. It is further to be noted that a communication was addressed by the Additional Secretary Education Department, Government of Bihar, seeking clarification regard to the appointment of primary teachers possessing DED, ODL qualification from NIOS. It will be relevant to the reply of NCT dated 6th of September 2019, which reads thus. I am directed to refer to your letter dated 29th of August 2019 on the subject noted above to say that your representation regarding appointment of primary teachers qualified with DED, ODL from NIOS has been examined. The primary notifications are those dated 23rd of August 2019, 2010 and 29th of July 2011. Determination of minimum qualifications, etc. The following points are inferred from the above notifications, copies. I will read as per NCT notification dated 23rd of August and 29th of July. One of the minimum qualification for appointment of teachers for classes 1 to 5 and 6 to 8 is 2-year diploma in elementary education. 2 is relevant, as your lordship is right, correctly observed. As per the NRC NCT order dated 22nd of September 2017, the DED ODL program NIS is only for those untrained in-service teachers and government-aided, private unaided schools appointed on or before 10th of August 2017. The duration of the program is 18 months. Hence, now this is important. Hence, for fresh appointments of teachers to primary and upper primary level, the notification dated 23rd of August and 29th of July 2011 need to be strictly adhered to. That is also a mandatory requirement. Now,
it does not refer to 22/9/2017.
No, for fresh appointments. So today we are not. These are not fresh appointments because these are all in-service teachers who are only changing employment.
We'll understand that. We just take this tentative view out of my head.
Please. So now, it can now, and this paragraph 43 is relevant, it can thus be clearly seen that as on 6 September 2019 is also the view of the NCT, the minimum qualification for appointment of teachers for classes 1 to 8 is a 2-year diploma in elementary education. It further clarifies that NCT recognition order dated 22nd of September was only for those untrained in-service teachers in government schools, in added schools, who were appointed on or before 10th of August 2017. It further clarifies that for fresh appointment of teachers for primary and upper primary level, NCT notifications dated 23rd August 2010 and 29 July 2011 need to be strictly adhered. Now, this can be, therefore, any school, it can be government, non-government. It is further to be noted that whereas notifications dated 23rd August 2010 and 29th of July 2011 specifically refer to powers conferred on the section 1 of 23 or 1 of the RTI, NCT recognition order dated 22nd of September refers only to the directive issued by the MHRD under section 29 of the NCT Act. It is thus clear that the entire scheme was for the purpose of providing a window to the in-service teachers, inasmuch unless they would have acquired the requisite qualifications prior to 1st of April 2019, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that the High Court has erred in holding that the 18 months diploma conducted by NIOS through ODL mode is equivalent to 2 years diploma, as provided in the notifications of NCT dated 23rd of August and 29th of July.
So what your contention with regard to that equivalence?
Yes.
Gone. It comes further. It further discusses that.
No, Malak. Today, Malak, I'm on this submission, this strand is slightly different and vastly different. What I'm saying is the court also recognizes, what does it say? It says for in-service and in-training teachers who are already in employment. So it can be employment which is private, government, non-government, whatever. We are giving them this window that by 2019 you will acquire this.
I think that plea that you are trying. Let's get off with this equivalence part. 45 and 46, 47 settles that.
Yeah, and 51 also, because what 51 says is that it could have issued. I'm one with your lordship. In fact, when your lordship is on equivalence, your lordship may count to 51. So may 50 and 51, because again that one-time window is very firm. So this is very important, because what I'm saying is, Malak, my first submission which I made, that once I have acquired the qualification at paragraph 50 again, as already discussed here and above, NCT recognition order dated 22nd of September 2017 was issued so as to give effect to the directives of MHRD dated 8th of September so as to provide a one-time window to the teachers who are already working and who, in terms of the 2017 Amendment Act, were required to acquire the minimum qualifications prior to 1st of April 2019. So if they acquired the minimum qualifications prior to 2019, then how can they be non-suited?
Please read the last line also. The said order.
The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention of the 2012 service rules and the advertisement issued on the basis of such service rules. I will come to Uttarakhand. The Uttarakhand rule has a 2-year stipulation which is not there in the MIT. Now, paragraph 51, if your lordships may come. This is where your lordships, because since may I read this? What your lordships have said, is reflected here. We further find that the finding of the High Court that the 18 months DEID diploma ODL course in elementary education conducted by NIOS is equal to 2 years diploma is erroneous. Therefore, there is no notification to that effect issued by NCT in supersession of its notification dated 23rd of August 2010 and 29th of July 2011, wherein it provides a minimum of 2 years diploma as a minimum qualification for appointment of teacher. At the cost of repetition, we clarify that the notifications dated 23rd of August 2010 and 29th of July 2011 were issued in exercise of its powers conferred under section 23(1) of the RTI Act, whereas recognition order dated 22nd of September was passed in pursuant to the direction issued by the MHRD under section 29 of the NCT Act. So now I'll take your lordship now to the last two, paragraph 53. And now your lordship may come to paragraph 53, and now your lordship will come to 56.
56.
In view of what has been held by this court here above, we find that the High Court erred in holding that the 18 months diploma conducted by NIOS through ODL mode is equivalent to the 2 years regular diploma, particularly so when there was no material placed on record to even remotely hold that such a notification was recommended by the expert body NCT. I have no quarrel with this proposition. I am agreeing with you. On the contrary, the communication dated 6 September 2019, the directives of MHRD are so as are the recognition order dated 22nd of September 2017, clearly go on to show that the 18-month diploma was provided as a one-time window to the in-service teachers to acquire the minimum qualification between and the outer limit of 1st of April 2019. In our considered view, the High Court has totally erred in holding that the 2 years diploma is equivalent to 18 months degree. Now you'll also come to paragraph 57, last sentence. They reiterate that as already discussed, the last sentence of paragraph 57, as already discussed here and above, recognition order dated 22nd of September only provides a window for in-service teachers to complete their course prior to 1st of April 2019. So now, my lord, you'll also come back to paragraph 31 where section 23 is enacted. So what does it mean? It means that, now you'll actually come back to qualification. my lord.
257, yes.
Yes. I'm sorry, I should have been able 23. Qualifications for appointment and terms and conditions of service of teachers. Any person possessing such minimum qualifications laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. That's one. Here, NCT, my lords, is the authority, the regulation, the notifications are there. Subsection 2, my lords. Where a state does not have adequate institution offering courses or training in teacher education, or teachers possessing minimum qualifications laid down under subsection 1 are not available in sufficient number, central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment of teacher. Yeah. Now proviso 2, my lords, which is the proviso in question. Second proviso.
Provided further.
Provided further. Now this is very important. That every teacher appointed on or in a position before 31st of March 2015 who does not possess minimum qualifications laid down under subsection 1 shall acquire such minimum qualification. The Supreme Court finding also that I have acquired a minimum qualification within a period of 4 years from the date of commencement of the Right to Children to Free Compulsory Education Act. This is retrospective. So from 31st of March 2015.
I got it, Mr. Adhik. I got it. What is your submission with the relief you want in this petition?
My today, my submission, the relief today I seek is that the advertisement have to be set aside. Because as far as there are 3 submissions that I have. In terms of the first submission, they are notified that disqualification has to go because it's a complete misreading. I have acquired minimum qualification. This is the Supreme Court finding in paragraph 55 and 56, penultimate paragraphs, and the ultimate paragraph. I have the qualification, minimum qualification in terms of section 23. So the advertisement has to be stated, and I have to be directed to participate in the selection process. 1. 2, my lords, as far as the equivalence part is concerned, in case your lordships is of the view that that equivalence is not there, and the Supreme Court has observed, the way out has also been provided by the Supreme Court in paragraph 51. NCT has issued recognition, has issued regulations. It is their stated stand. So it is now in requirement of their statutory duty under section 23(1) to mandamus can be issued on the basis of the judgment that you issue a circular specifying equivalence, because you have already said this is the minimum qualification. 3, my lords, the Assam rule, which is at page, my lords, 89, my lords. Assam rule, which is at page 89, because your lordships does not have the prohibition of Uttarakhand. Assam rules adopts 23rd of August, and what is more importantly, your lordship will just have it's at page 89. I have extract.
I've got it. The RTE rules.
Please, the minimum qualifications for a person to be eligible for appointment as a teacher in elementary schools shall be notified by the National Council of Teacher Education number so dated 23rd of August, which is the 2-year. Now, the second part is very important. The provisions of all rules, notifications, orders of the government prescribing qualifications for teacher, which are repugnant to the stipulations laid down, stipulation, not stipulations, not stipulation, laid down by the National Council of Teacher Education stand superseded. So today, the 22nd of September 2017, which are the recognition order, is an NCT stipulation. So how can the Assam?
Mr. Hazarika, I'm not sure whether you have been brought to your notice. We have another rule specifically for the service wherein the advertisement has been issued.
Yes,
you have a manual, this manual.
Please,
it's called the Assam Elementary Education Provincialization Rules 1977.
Yes,
and the provisions of Rule 3. B, C, B, down below. I'll just read it for you. The minimum qualification of a person to be eligible for appointment as a teacher in an elementary school shall be as per notification issued by the state government from time to time, in conformity with NCT norms. These qualifications shall be applied to all category of elementary schools. So the rule says NCT, and you are developing an argument that that stipulation with regard to that 18 months is also inbuilt there. And unless you don't exclude that from your rules, you cannot prevent these people from.
And my lord, they have acted upon it because 2019,
19,
2021,
they acted upon it.
2023, they have acted upon it. So many of our, and today, my lord, 100.
We'll hear the AG on that point. Yes, Mr. Secretary.
Yes, Lordship, I fully agree what my learned friend had just said, that 2019-20, we do it. Lordship was a
There
part
is no
of that
estoppel against
litigation.
you.
That litigation is still pending. But now
There is
with
no
the
estoppel
recent
against you.
Supreme Court judgment, Lordship, there is absolutely no ambiguity. It is very clear. Paragraph 51, paragraph 40 onwards, and paragraph 31 and 33. What remains, Lordship? We cannot violate the Supreme Court's order.
Now, Mr. Hazarika wants this court to issue a mandamus to the NCT authorities for incorporation of that in that rules, in that regulations. What do you have to submit on that?
On that, the Supreme Court has also said that till now NCT has not done anything.
So when the Supreme Court has not done
Anything,
should
how can this
court-
honorable
No,
court
no,
would-
address me on that. Should this court come in?
Absolutely no. This will be clear violation and in conflict of the Supreme Court judgment. Had there been any scope in the Supreme Court judgment, Lordship, that scope would have been there, but there is no doubt or any confusion regarding the language used by the Honorable Supreme Court, especially paragraph 51. Let us start from paragraph 40, Lordship. These are findings. What my learned friend was placing, basically those were arguments.
Mr. Sakia, you can come straight to 45, 46. I think
45
that
also,
is.
Lordship. 40, 41, 42, 42,
I've seen, I've gone
45.
through it.
Yes, Lordship, I am not repeating. 45.
45.
In the impugned judgment and order, the High Court has relied on the judgment of the High Court of Patna in the case of Sanjay Kumar Yadav and High Court of Tripura in the case of Raju Nama. It is to be noted in the judgment of the High Court of Patna, though a reference has been made to the communications addressed by NCT to the Additional Chief Secretary Bihar, it brushed aside the said communication on the ground that it is nowhere mentioned that the said course cannot be treated at par with the 2 years training course. In the absence of specific order of NCT granting equivalence to the 18 months course with 2 years course, in our view, the High Court has totally erred in finding that since the communication does not mention non-equivalence, it would be deemed to be equivalent.
You
In
took care of
fact, in the earlier 2 rounds,
46 will clear.
46, we find that the High Court of Patna has totally erred in not giving effect to the stand of NCT. As a matter of fact, we fail to understand as to why NCT did not challenge the said order when its specific stand that the said 18 months course was only for in-service candidate and not applicable to phase ones was rejected by the High Court. We also fail to understand as to why communication dated 6 January 2021, NCT decided to accept the said judgment of the High Court of Patna.
47.
47. Insofar as the High Court of Tripura is concerned, it again relies on the judgment of the High Court of Patna in the case of Sanjay Kumar Yadav. We therefore find that the views taken by both the High Courts of Patna and Tripura were not correct in law. What remains, Lordship, thereafter? And paragraph 51.
The submission, Mr. Hazarika, you are making with regard to a mandamus to the NCT, that cannot be issued today. That we'll have to hear the NCT first.
Yeah, no, yes,
Now,
no.
today only we can consider whether we have to permit you
To participate in the
terms of that advertisement and the rule position read in the light of the decision of the Supreme Court. That's all.
Yeah, so my
That extent only. The other part can come in once the matter is finally considered after hearing NCT.
I'm in entire agreement. No, but let me say, and in all respect, because firstly, because the rule, what my learned friend was referring to because the Supreme Court at paragraph 53 has said that it did not, that the High Court of Uttarakhand erred because because there was no challenge to the rule position over there also. So, today, my submission would be therefore, as far as
that, Mr. Subject to correction, is only an approach with regard to one of the contentions raised.
Please.
The Supreme Court gave its verdict in paragraph 46, 47. Because
Yes.
I'm again reiterating this thing you just cleared to me.
No, but it also.
As I have read, NCT never said these two to be equal. It was for the first time that the Patna High Court said both are equal, do it. The Supreme Court saying that is bad law.
Therefore, my submission was because today, because eventually it is the ultimate and the penultimate paragraphs of the Supreme. The Supreme Court says in paragraph 56 and 57 that you have acquired the minimum qualification in terms of section 23. That if I have acquired the minimum qualifications of terms of
Okay. Let's test that. Let's
Yes,
test that.
very much.
Let's test that argument. If that was the intention of the Supreme Court, why did it interfere with the judgment of the Uttarakhand High Court and did not pass an order to the NCT to incorporate that?
Because the Supreme Court, my lords, at paragraph 43 made a distinction between, I think paragraph 43, just a minute, 43, made a distinction that it is not for fresh, that for fresh appointment it cannot happen.
This is fresh appointment, Mr. Hazarika. You are not a appointee under the government or in a school appointed in terms of norms of the government. You may be anywhere. You may be a private institution, individual. You may be a contractual work employee with the, or an ad hoc employee with the government. But you don't have a root in the government service.
So may I just, let's look at it the other way around. What is the implication of this judgment? The implication of this judgment that this 18-month course is a valid minimum qualification in terms of section 23.
Yes.
Now, therefore, if I have a valid minimum qualification in terms of section 23, does it mean, what is the implication? The implication that I can not only continue to be employed in my present position, I can also be employed elsewhere.
That's the catch. That's the catch.
It isn't the catch.
That's the catch. If you come to the
cannot be.
decision of the Supreme Court, here, it has categorically said
Fresh appointment. Fresh appointment.
it will not appoint to fresh appointees.
No,
Mr.
I
Just try to factor in this also in your argument. This 18 months was only to get the teachers across the country who did not have the minimum qualification with regard to RTE achieve that. This was a student-centric approach of the government. It was nothing to do with the teachers. It was a student-centric approach so that the students are not deprived of a proper education from a trained person. Now, keeping that view in the mind, as far as I have understood, the Supreme Court had proceeded.
So
What do you have to say?
So my first submission.
I'm examining this only with the view whether I should permit you to appear in the elections.
I am grateful. As far as permitting me to appear in this whole process, my lords, as I said, let me address this query of yours, lordships. Today, if I have that's what falls from your lordship is that this being a student-centric thing may have been the perspective, but in terms of the statute, in terms of section 23, I have the minimum qualification. Having acquired the so fresh appointment would mean, because why it also is, and I think that is because it says that the 6 months internship is subsumed in that 18 months.
Why?
Because I'm an in-service teacher.
No,
Yes.
Mr. Hazarika, you read it further. It was because that time was not there.
No, very well.
Cut-off date to come into operation.
No.
Only 18 months were left. It went ahead.
So regardless of that, today the court has held that I have the minimum qualification. Penultimate paragraph, it says twice, and that was what I wanted to read to you. It says I have the minimum qualification. If I have the minimum qualification in section 23 as a teacher in terms of section 23, and I am eligible to continue as a teacher in my school, why can I not be a teacher? It says fresh appointment. What the Supreme Court meant was a fresh appointment in terms of someone who was not in training. So that is why it said this is a separate class. That is what the paragraph 1. 2 minutes as far as the facts are
I got your
concerned.
point. I got your point.
As far as the facts are concerned, all along the Assam government, the central government, everyone, MHRD, all of them have today 2019, 21, 23, I have been recruited. Now, and Supreme Court in paragraph 51 has also provided the way.
Got it. So you mean to say that the Supreme Court judgment has not considered that effect of 23 provision.
Yes.
So it's per inquiry. I'll have to declare it per inquiry.
No, it is not. Because the Supreme Court has not said that they are not,
Did not.
did not say that they would.
This
But
direction
no,
ratio is binding on me.
No, what it meant in terms of fresh appointment was someone who was not in service. Today in service means someone can be in service in a private school.
No, the advertisement says any person in government service in an LP school cannot apply. You got it. We will examine. Don't worry. We'll examine.
Well, at least permit me to also participate in the process because after all, we have
I'll examine that because for your information, the government is extending the date till 12th.
Please, Mullah.
So till 12th, right?
For it is general. not
Generally, for
specific
all,
to
for all. So these orders, I'll pass it tomorrow morning. Let me consider. I'll pass it tomorrow morning.
But we have serious objections because we do not
Well,
want to. do
I
anything in
have
quick-
understood your objections. Mr.
My objection is for any kind of interim order. Lordship may be pleased to issue notice. We have
Will
no
do.
doubt. Paragraph 15 very clearly takes care of section 23, section 29, and as well as all the notifications. And also whatever has Lordship has regarding the 1977 rules.
293.
29. We cannot
Go beyond.
violate that. We cannot violate that.
Because I had a doubt first.
Till date,
As Mr. Hajarika is trying to project, has to build up a case, that there was a rule with the Uttarakhand government. That rule was violated and the High Court Supreme Court has made some observation in that line also. I was in doubt as to I did not know that this provision was added. While consulting the book, I got, we are in a better, the state, I think has put itself with NCT.
yes.
Yes.
Or with NCT.
The recognition
And-
order is a statutory
And
order.
Lordship, paragraph 53, last line.
Okay.
The High Court, in our view, if it is respect of the other cases, the High Court, in our view, could not have issued such a mandamus contrary to such service rules.
Yeah, that is, Mr. Hajarika is also trying to take, but that was one of the limp of the arguments. The
And paragraph
exact-
51 very clearly refers about the
exact-
notifications.
exact nerve of this judgment is paragraph 45, 46 and 47.
Yes, Lord.
Because other than Patna, High
And the contemporaneous records in paragraph 51.
we'll try.
Grateful.
Let's see how best we can help you.
And
I'm-
in 19, 20, 21, we did it because till that time, the Uttarakhand judgment was not there. We are with Hajarika, but today we cannot.
No, Mullah,
The Supreme Court
It is
has-
up
That's
to
why
the
my
Yes.
opening,
yes.
opening liner was, I am
But-
supporting him, but today I cannot.
You
say.
cannot.
My learned friend Milad only has to construe the judgment as the Advocate General in terms of the manner in which it is given. But in paragraph 56 and 57, that's enough. He says, I'm
The
qualified.
problem, Mr. Hazarika, I am facing.
The irony is that when my lord Justice Nair was on the other side, we always saw the Patna High Court and Tripura High Court against him.
This was the argument maybe I could have done. Let me consider. Tomorrow morning, 10:30.
I'm grateful. Mullah.
Highly of the
At least I was the delivery of order. I'll not dispose of the writ petition. I'll only consider the interim prayer and issue a notice. Okay?
We are obliged.